first of all, sorry for the delays and sorry for the technical difficulties. We're just not able to get connected to the screen there, but we'll have the information on the laptop if anything needs to be seen visually. Let's go ahead and call the meeting to order and begin with the roll call. I'll begin with myself, Caleb Davis, Chairman.
David Hall.
Scott Fuller.
Bill Bennett.
Rob Whitwood.
Wade Purdom.
John Krieger.
Claire Marley for the county.
Al Isaac.
All right. Looks like we do have a quorum, and the first action item on the agenda is the election of the chair.
Oh, Ron.
Oh, yeah, I'm sorry. Sorry, Ron, I forgot you're digital tonight.
All right, you got it.
All right, we'll add Ron to the list there.
Ron
Thank you for
Self.
calling in.
All right.
So this is the, all right, now open, file 23-0180, Land Use Code Text Amendment. Boundary County has initiated an amendment to its subdivision and zoning codes to repeal current section 4 enforcement of the Boundary County Zoning and Subdivision Ordinance and adopt a new enforcement section establishing procedures, remedies, and penalties for addressing land use code violations. The proposed amendment would define violations and declare them to be a misdemeanor, set a process to review zoning complaints, seek compliance, and authorize various remedies to abate violations. All right, so now that we're on to this particular application, Claire, do you want to talk about the process again,
Sure.
or the nature of the application?
So everybody who was here for the first one heard the announcement about how the process works with respect to testimony. The only thing that's different about this is we'll go through the same process of presenting, and then the chair, once we come to the public testimony, you can testify in any order. It doesn't have to be those in favor and those against. So you'll just call out that it's time for public testimony. I do have 3 copies since we don't have a screen to show, so it looks like I have enough to go around in 3 groups of you in case you want to follow along or have any questions.
Thank you.
You got one. Okay. Anybody else? So here, as you recall, Claire Marley, excuse me, I forgot to say that for the record. As everyone recalls, we began this discussion about a year ago. We were able to meet with the county prosecutor, the sheriff, and the undersheriff. We discussed our situation with various complaints that have not been able to be resolved, and the status of our current code, which is chapter 4, which had some challenges that kept us from being able to administer some of the abilities to see files that were violations closed. And as a result, there is now in front of you a proposed replacement chapter 4. So the proposal is that the entire chapter 4 would be repealed and a new chapter 4 would be adopted, known as code enforcement. And I'm gonna run through slides again so I don't forget to say what it was that we had for changes so that everybody can at least hear that. You won't see it. So first of all, I think we had shared with you that we have about 50 violations in various stages of hopefully being abated or working on those. That's from 2020 through this time frame today. And the outcome of our meeting in August of last year was that we were going to look at this amendment. We brought the suggested changes both to you and to the Board of Commissioners so that they were following along with what the proposed changes were. So you've had a chance over, I think, about 4 sessions to look at these changes and to give feedback to me and to our prosecutor as we went through that. The first and biggest change is that the proposal is that the infraction process would be taken away. There are questions about whether a county can issue an infraction versus a city which has a police force. And the new penalty would be, or would remain as the misdemeanor. There was some public concern about, well, that could be a lot. Most of the times when those punishments are, the maximums are $1,000 or 6 months in jail, or they could be both. But rarely, I've done 30 years of planning work, and I have only one time seen one person go to jail, and it was for a gross violation of a landfill, sewage disposal, and junkyard that was acres in size. And the county failed to get any, ability for them to clean it up, and so the judge said, it's time for you to clean it up, one time in 30 years. So typically, that misdemeanor is not imposed. The goal is that you work with an applicant or a landowner to try and, get compliance, which would remain the goal of the county through this process. The other major change is, the current law says each week is a new and separate violation. The change would be each day is a separate violation. It means you have the opportunity to say there's a new violation occurring every day. Again, that's rarely used. It's usually that single violation, and they attempt to get compliance based on that. One of the other troubling sections was that there was a way that you could pay a fine between $1,000 and $5,000 depending on your violation, and then you would be forgiven of that violation, and the county could come back and correct that. So that's proposed to be removed. And then the other important part of the proposed code is that it would say that if you have a violation today and this new code is adopted, that violation can still be treated and addressed even though you have a new process for looking at violations. The other change is that the document you're under now lists all kinds of different violations, and if you miss one, you might miss a ability to look at a violation. So the newest one, you all helped, the P&Z helped to craft that language where it simply says any action or inaction that violates your land use law is considered a violation of the code. So it just simply simplifies that. And then, again, the second part of the code section, if an illegal structure, or a structure was built without a permit or didn't meet setbacks or had other issues, they could pay a fine up to $5,000, and it says up to, and the violation could remain. And so that's also being removed. In its place is a series of remedies, and if you have your code in front of you, the remedies section is enumerated, and I am gonna go ahead and go through that since it would have been on the screen. So starting at page 2, where it says remedies, it begins with a list of opportunities that the county has, one of which is a stop work order. That can be used in an event where there's a health safety concern, where they could place a stop work order, or else to be able to stop it until that violation is cleared. And one thing with your discussion that we did add to that is that in the event you have a house under construction, it's like today, it's raining, we would allow them through an agreement to close that in or at least protect it so that they don't lose the structure while we're working on whatever their violation might be. That has to be worked with the prosecutor so that that allowance is there, and then specifically says that doing that doesn't waive our right to still declare that's a violation and work to get it cleaned up. The injunction opportunity was in your code. It's tightened up a little bit as to its wording. It just simply says that the county has the authority to seek from the courts a temporary or permanent injunction. And number 463 allows civil actions. And in this instance, through the discussion with the prosecutor, it's the Board of Commissioners who brings a action that's a civil action as the county's official head of the governing body. They're the ones who bring that. Civil actions are at 4.6.3 of our draft. 4.6.4 allows the recovery of the losses the county might spend on going to court or following through a process to bring about an abatement, and that again adds a little bit of teeth to allowing the county to take care of a violation, but also not to lose money at the same time in doing that. 465 is withheld permits, and it says that no permit may be issued or granted on other land use activities until the subject property is in conformity. 4.6.6, very, very simple statement. The prosecutor is authorized to enforce this ordinance. 4.6.7, notice to title. We've had quite a bit of discussion about this. A number of counties use this. And what it says is that if you fail to obtain an abatement, one of your other tools would be to file an injunction, or excuse me, not an injunction, a notice to their title that says there's this violation on the property, this land use violation. And what everybody's concerned about is that we'd always want to make sure that you're saying what is in fact the case and that you don't want to place a cloud on the title. So the ultimate decision on this one was that we would only have that opportunity to place it once court determines there is in fact a violation, so that it protects the county as well. As far as the process for the complaints, the Planning and Zoning Commission was interested in basically keeping our 2-letter process, which first starts out with a regular notice by mail. We often add that as an email too, simply because people communicate that way. But the second, or the first letter would be, we believe there's a violation, here's what we see or hear, and please respond to us, and advise of your ability to abate this, or let us know if there's no violation. So it's that first letter that goes out. If they fail to respond in the timely manner set by the code, then the second letter is a certified letter, and it announces a penalty ability for the county to penalize if there's a failure to abate, and advises that if not abated, it goes to the prosecutor. So that's the second letter, which is pretty much the same as yours now, with the exception that your current one says they just had to respond, so they could say hello to me, or they could say thank you, or whatever, and that would be sufficient. But the process would be that they have to abate it, or they have to show us why it's not a violation. So slightly different language, but somewhat the same as the objectives are to first allow them to respond and allow us to work with them, or the county to work with them to abate. Other changes, your code now says they may report directly to the sheriff, and the sheriff doesn't want that to happen. We need to gather the evidence first, we need to know there's a violation, and then it needs to go to the prosecutor. The exception that the sheriff makes is that if in the work of the planning department we come across violations that are not land use violations, that are like child welfare issues, that we have to report those. We're aware of those in our work that we do, but he reminded us of that. The county does have the opportunity to seek immediate action if there's a threat to health, safety, or welfare. And I think that is supposed to be what, let's see, 2-step process I talked about. The remainder of my presentation, Chair, was to have up in front of you the code, which everybody I believe has a copy now, and then to go through a quick bit of information about who all was provided this information. We had probably about 20 to 25 taxing districts in the media who were let know about this change. And then we also did the notice in the newspaper, and we received no written agency comments and no public comments other than John Poland, who had actually provided that as we were working on it. I summarized that in the report, and his questions were about the concern about lack of infraction options for minor violations. Meaning that the county could be less inclined to act on violations if it's the misdemeanor is the only choice. But we do have other things that we can, I'm saying this now, that there are other things we could look at and not necessarily just do a misdemeanor. And then John also says a clear statement that each day is a separate offense is needed. He agreed with the remedy section for action by the commissioners, a public official, or a private citizen. Notice to title should be considered a last resort, and I believe you had a copy of that letter in your packets. And then, as always, the requirement of the adoption of a text amendment is one that needs to be shown as meeting your policies of your comprehensive plan, which were listed at the very end of the report. And then, as always, your decisions are sent to the Board of County Commissioners as a recommendation. And that's the end of it, unless you have questions.
All right, thank you, Claire. Any questions for staff? Kinda? Well, you can take a moment. There's no rush. Yeah.
What is the time between the first and the second letter if they don't respond to the first letter?
I need to look at that.
Is it on there?
Yes,
Oh.
14 days. So the first one, the 4.7.1 notice of complaint. Then the second, the one that contains the certified letters, again, 14 days.
Okay.
So is that based on the date of delivery or date of post-mark?
We use what typically is not counted are the day it's sent out, and then the 14 days, we count forward 14 days from the day sent after the day.
And then 14 calendar days, not business days.
Unless it says otherwise, it's always calendar days.
Okay. All right, any other questions for staff?
Not at the moment. Not at the moment. I reserve the right to ask questions.
You most certainly do. No, I totally get that. I mean, we have been going through this process for months and months now, and we're kind of getting to the end phase of it, so I totally respect if you want to go through and fine tooth comb yet again as we get through the last steps of this process, so there's no pressure to keep casing going forward, but yeah, if you've got questions, highlight things. And
I'll
we can
start with the
come back
easy
to it.
one first.
Okay,
I appreciate John Poland's letter,
yes, certainly.
so that's a question for him on wording, on constitute versus constitutes.
Yeah, that needs to be fixed.
What number are you on?
4.5, I was referencing, John's letter. But I'm not the great,
Oh, okay.
I'm not the great, orator, so I don't.
Actually, that's, I was gonna bring that up later, but that does need to be.
Oh, it's
corrected.
typographical.
Yeah.
Oh, gotcha.
I think that's clarified.
Yeah, yeah,
right?
I got you.
I don't think it's
We're
substantive.
good on that?
He caught it way back in October.
Yeah.
Good job.
Good job, Don. All
I
right.
don't like the misdemeanor thing, I just think that's too harsh.
Well, it's, like she said, it's not the only option.
I know, but I don't know.
I think the reasoning behind that is that we do have some offenders that we just don't care.
Agreed.
And when we can't apply monetary pressure, fining them or something along those lines, then it becomes more of a, what else do we have? Like, I'm thinking like some of the junkyard situations that we've seen over the years.
And I could also add to that, Claire Marley, for the record, that in my time of doing zoning abatement, and the times that we've gone to court, rarely have they said $1,000.
Sure.
It's more often gonna be 2 zeros instead of 3
That's why it
zeros.
says up to.
Yes,
Yeah.
up to, right, yes.
And on that note, the current language that we have in our ordinance, what does it state with regard to misdemeanors? Would you be able to
Oh,
pull
I
that
have it
up?
here, yes. I could pull it up, but you wouldn't be able to see it.
That's-
I do have the code section here, and are you asking about what the violation is?
In relation to misdemeanors.
Oh, okay, so that's state law. State law says it's $1,000 or 6 months in jail or both, up to is what it says. And are you asking me to
Well,
recite
I'm
He's
that?
asking if the current ordinance.
I think what
says-
Kate was asking is, are there any misdemeanors currently in the ordinance?
Yes.
Yeah.
All right.
Yes, so there's a precedent for that.
So I just wanted to highlight the fact that that's not necessarily something that we are creating and adding to the ordinance with this process, but it's already pre-existing. Does that make sense?
And also, we're not the ones that actually have the final say in that anyway, it goes to the prosecutor as a misdemeanor,
Correct,
right?
and eventually to the judge.
And they can do that entire plea process or have that conversation with the.
Yeah, so here's my, I'm not gonna word it very well. So say you're building something, you've made a mistake, you're building yourself. You get a fine, you're like, oh, what do I do? You go to the lawyer's like, well, I'm booked out for 3 months. Are you still getting fined like $1,000 a day by not?
No,
No, that wouldn't be the process at all. And we do these now, but the process is the letter goes out and they typically rectify. We see a pretty good percentage of folks who come in. For that, there's no fine at all. We're just getting the permit processed and provided to them. In the instance where a fine might eventually come, it would be, they would be cited, we would go through the prosecutor and then on to court before there would be an imposition of a fine. Your earlier question about do we have misdemeanor, it's at current code 4.1.3, so it is there already.
Are we, so if they respond to the letter and they say, I need more time, is that something we
It
also?
happens all the time.
Right, exactly, so
we
that's
have-
one of the things I think you're concerned with the most is the
Right.
amount of time.
I just like,
14
if
days
you,
is a
if you
long time.
really like have a bad problem, like, there's like 2 lawyers in town, what are you gonna do?
Pay
You
more
know?
money.
No, I mean, they're not
Yeah,
gonna
no,
do
I get
anything,
you, I
like,
get you,
you're out of
exactly,
line,
I get you, so I think the real thing is we just want communication back about
Right.
what's going on, right?
There are some violations that have existed prior to 2020 that, I'm sure some in the audience know about, that have been here for a long time without ability to abate, and those are eventually gonna have to go to the prosecutor or are already at the prosecutor. But your question about, do we give them time, we have one current one that's a floodplain violation, and it's snowing out, and it was snowing out, and they're trying to work with their surveyor to finish up a permit, and we've given them, I think, till April 1st, and it's
So it's
the
very
desire for,
discretionary, so.
and it's also a desire for compliance.
Right. Right. So as long as they're showing an intent to try to comply, then we have the discretion to establish whatever timeline
Yes,
necessary.
and we'll work with the prosecutor, we'll let him or her know that we have this situation and here's where we think we can go with it.
Right. Does that help? Like, are you
Yeah, a little
still
bit.
issues
I'm
with the
still-
rigidity of it?
yeah, that's right. I have issues of my own.
Yeah, I think we're trying to get the, I refuse to respond, or I refuse to do something about it.
Yeah. Just add a
But
little.
if somebody
bit more.
does respond, you know, they're gonna have an avenue to work with somebody if there's extenuating circumstances, like weather, or can't get legal help to sort it out, or something like that. So I think we're really trying to target people that don't want to do something about it.
And deliberately are adversarial to any process that we put in front of them to try to rectify the situation, because there's not enough weight behind our position.
Correct, and that was the reason that this conversation started, it wasn't about all those who are already doing, or responding and taking care of it. It's the ones that step up that don't.
It's more of a bad faith situation than anything else.
What if you have a contractor that's saying, oh, I'm fine, and then the homeowner is still getting notes from the county saying, hey, you're in violation, but their contractor's saying you're fine, you can keep building.
It's the landowner.
I've seen that.
I mean, like, I saw that with the Cabinets Northwest, and like,
Yeah,
Right.
whatever.
So Scott, are you, airing concerns about the lack of discretionary, power to
Sure.
enforce?
Yeah, I mean, I don't know the right answer. Sorry.
No, that's okay, no, I appreciate you bringing these things up, because it has always been our intent from the outset to not come up with anything that is onerous.
Right.
Nothing that is not consistent with the culture of our county. We are very liberty-minded, and, we are advocates for people's personal property rights. So, I definitely appreciate your sharing and, wanting to bring up things like that for
I'm
discussion.
not wording it very well, but I'll try to do better.
Any other
It seems like
questions?
there's some kind of caveats, like we can kind of, I don't know. And then you get to like the crazy junkyard people that are just gonna do what they want anyway, like. I mean,
So,
I mean, I think
just a reminder, we're not really in deliberation.
Yeah,
I-
sorry.
No, it's okay. I just wanna allow this stage to be directed, to staff for questions. We can always open that up again. I just wanna do that as a reminder, and then the next, we're gonna engage with the public. We'll close public comment, and then we'll enter into deliberation and go from there. So, any questions for staff at this moment? I'm not trying to stifle that. If you do have questions, that's okay. Okay, all right, thank you, Claire. Now's the opportunity for anyone here that would like to speak, concerning this particular application. So please state your name and, please, share with us your thoughts.
John Pullen from Naples. To clarify some of the concerns about the way the ordinance would be enforced, could possibly planning and zoning, maybe Claire could go over some examples of saying, hey, these are some of the ways that we are currently handling these violations, this is the process we follow, and that might show that this wouldn't be abused. And we'll say, hey, if we do have this particular kind of violation, this is what we're going to do. And if it runs into a particular concern like has been mentioned, this is how we would handle it. So it doesn't immediately jump to, you know, the maximum possible penalty being imposed right off the bat, because that's not the way it would be enforced. And as from what I understand, that Claire's already sort of expressed that that's not the way it's done. It's done in a sequential process, and fines don't really get imposed until the judge looks at it, really. So if maybe perhaps you guys could go through that one more time and kind of summarize the way it's done and provide an example, maybe that might help alleviate that. And then another question I've got is, it says here in 4.6.3 that the Board of County Commissioners may commence a civil action. I'd like to know how much power the commissioners have to take action against a violation. And I ask that specifically because I know that from here on, our prosecutor is going to be very much overworked. And any violations that get written up are probably going to get stacked up in a very large pile, because there's criminal matters that are gonna take precedence over civil matters. So if the commissioners have a way of seeking action on their own through the court system perhaps, that wouldn't take the prosecutor's time, it might be more effective that way. Anyway, so if you guys could address those two issues, I think it would help.
Thanks, John.
Yeah, good question, John.
So just to clarify, John, the first one that you're asking for is more like a schedule or a procedure of escalation of how that process would play out depending on the violation, is that what you're looking for?
Yes,
Okay.
You mean listed in the ordinance?
not necessarily in the ordinance, but in a practical sense, to say, and this is where, you know, Claire could just say, hey, this is the way we do this. This part says this is what we do. And it looks like, you know, letter, notice of violation, then action of the prosecutor then goes back, talks to people, you know, that kind of thing.
So what the procedure would be?
Yes,
Okay.
yeah, as applied in real life.
Okay.
Do you want me to do
Yeah, I
that
would
now?
like.
Yeah, yeah.
Okay, yeah. There's-
Everybody, this is our list of violations, it's, I think it's smaller than 6 point right now type, starting in 2020. The blues are ones that we were able to resolve, the green are, excuse me, the blue are unfounded, meaning they wrote back to us and said, hey, I'm not really doing that, or, whatever, they got their permit and we didn't find it. And then the green are resolved, that, they had, been abated because they came in and got their permit, for example. The orange are the actives, so on this page there are 1, 2, 3, 4, 5, 6, 6 major ones. In each of those, we've explained what we've done, what we've attempted, how many letters we sent, did they call or write to us, and eventually then it goes on to the prosecutor for what comes next. And sometimes when it gets to the prosecutor's asking us to do additional things, like to, maybe schedule a visit with them, we've done that, to get additional photos if there's a lack of good evidence. So it's not all of a sudden you've got 8 or 14 plus 14 and now you're on to court, it's very rare. And also, the attorneys don't want to go to court, it's expensive, it takes a lot of time, they'd rather we were able to solve it. So while it gives more tools, the goal is still gonna be the processes of communications and working with the vendors. So I know you couldn't read this, cause I can, on the type size it is, but it's hopefully a graphic representation of what we're doing.
And then, Mr. Coleman, your second question?
Oh, the civil action
The civil
question.
actions, yes.
So that comes straight out of Idaho code, and it's the authority of the commission to bring civil action, but it's actually court actions. They can't necessarily do anything outside of that court. And if that needs to be strengthened in that section to say it's court, it's meant to be court. But they do need an attorney to file that. But they, rather than the prosecutor, have the right to begin a civil action if something is not solved, and they would have to ask their attorneys to begin that action.
So could the commissioners then hire, like to supplement the help of the prosecutor, they could hire an attorney to say, hey, we want you to write this guy up for violation, start a court process, could they do that?
I know in some counties they can, I don't know in this county if they would or would want to do that, or whether they would want that prosecutor to be the one to lead that.
Okay, but the ordinance does allow for that though.
Yeah.
So it
Although
could be
it
done if
doesn't
needed.
exclude that, it just says they have that right to bring the civil
Right.
action that comes straight out of Idaho code.
Yeah, it doesn't say, I guess it doesn't say how the county commissioners may commence it, just that they may.
Right, right. And that doesn't need to be clarified necessarily, it just needs to be there as an option.
And if I'm understanding right, the how and all of that is defined by Idaho statute, so they would have to operate within state code
Correct.
parameters.
Right, and I did have that slide up as to where that came from, but we don't, I can't see
Right.
it.
So, I guess I do have a question, so it looks like some of these, like, the civil actions that are, so 4.6.3 and 4.6.6, did a lot of those come out of Idaho code?
Yes,
Cause we don't word it quite like that usually, and I was like, that looks like it came from somewhere.
Oh, you mean the wording? Or just the ability?
I think the wording made him think that it was coming from Idaho.
Oh, gotcha.
That's what triggered his thought process.
The authority comes from Idaho code, the wording comes from the work that I did with the prosecutor to write this.
Okay.
And
Alright.
number 4.6.6, prosecutor action, Tevis had asked that it just be simply that the prosecutor has the authority. That's just simple, that it has authority through Idaho code to take action.
But that comes from Idaho code.
The authority
The
comes
authority
from Idaho
does.
code.
Okay.
It's just getting explicitly codified here.
In other words, we recognize it, I see.
Mr. Cullen, did you have anything else that you would like to address?
No, that covers my concerns.
Well, thank you very much, and I do appreciate your participation over much time, and providing us your feedback has been very valuable, so thank you.
Your
for
letter
coming
was
and doing
great, thank you.
that. All right, anybody else would like to speak? Yes, please state your name for the record.
Adrian Norris, health, safety, and welfare, is that defined?
Idaho code doesn't specifically define it, and the jurisdictions are allowed to consider what that means. Typically, the ones that I've seen that used for, the most evident one is a floodplain situation where there's hazard that's been created by somebody's action. We have one we're working on right now where they actually altered a stream. So that's a potential where you could say it's obviously safety and likely could be, health. They vary, and
So it's left to interpretation?
it is.
Okay, and so that was my next question is so if somebody is building and it's not necessarily an ordinance violation, but they are, their build is actually damaging their neighbor's property, would you be able to intervene on an immediate, or would it have to go through due process?
I think that depends on what that damage is and whether or not it's truly a civil action between two parties versus the county. It really depends on what that situation is.
Okay, thank you.
Is that all, Adrian? Anybody else would like to speak with regard to this application?
Well, quick question on follow-up on her question. If there was an immediate issue, the county could issue a stop work notice or something along that line to halt to that as well then, right?
Yes.
Okay,
Could,
thanks.
could you do that now, or not until this ordinance, or?
I need to
Or
double
amendment.
check whether that was an option. I think
The
it
stop work
was. I
order.
think there was an injunction listed and could have been,
So,
but it says take legal action to restrain, enjoin, or stop.
Right,
where was health, safety, and where was that?
well, she mentioned it in her comment,
Oh,
at-
4.7.3.
yes.
It's the very last one.
Oh, I see, right, yeah.
I'm just thinking like, let's say they're cutting trees down to build a house or whatever, and it's falling on, you know, their living area or whatever, and it's obviously gonna cause an issue, is there gonna be an ability to immediately stop it?
We would have to make the connection that it's a land use violation, so if somebody's cutting timber and we don't necessarily see that tied to a house building, it might not invoke the land use laws, it might be the sheriff who needs to
Okay.
deal with that.
Right, okay, thank you.
All right, anybody else before I close public comment? Because once it's closed, it's closed. Okay, no one? All right, thank you very much. So let's go ahead and deliberate on this application and these changes proposed to our ordinance. Just at the outset, I would just like to make a few comments regarding this. This is, as I alluded to before, this has been a long process. We've gone over these things over and over again, and we're not changing the uses that people can have on their property. We're talking about being able to enforce the ordinance as it's already written. And historically, we've had problems, and people come to us and have concerns over the lack of teeth to be able to actually enforce that which is already in our code. And it's been very frustrating. And it's certainly not my goal to come up with anything that is going to make government bigger, make government oppressive, and take away people's property rights. I believe I speak for everyone that the intent here is actually just to maintain that which is already codified in our ordinance, and allow the county to also have its checks and balances, go through the appropriate streams, because the language as it's written right now is not appropriate for enforcement. Case in point is the sheriff's office. You know, the way the code is written right now, we don't have codified in our language the appropriate streams to go through and the right sequences. So those are just some of my comments, just on a more broad perspective that I'd like to open up with.
I agree.
Yeah, and it's, I mean, this, like you said, it's really nothing to do with changing anything in the ordinance. It's clarifying and giving us a little bit extra weight to enforce things that we've already agreed as a county on how we want things to be. So, I mean, I get the concerns that you're talking about, Scott, about being heavy-handed, for example.
Sure.
Or not exercising restraint and having additional, penalties and fines imposed and those kinds of things. But honestly, it's gonna kind of be up to the board itself to deliberate on a case-by-case basis anyway, how we wanna proceed in the situation. And this gives us the options that we actually have more range, in my opinion, now than we've had before.
Is the fine per day?
It could be.
It doesn't have to be.
And then I have a question too, I guess on John's thing on the Board of Commissioners. How would it even be approached? I mean, how is it, would the complaint come to you, Claire, and then you put it to the?
I think that's appropriate.
Yes,
Yes, please.
So, it goes through this entire process.
Right,
And then reaches generally the prosecutor, but the Board of Commissioners would have the ability to say, we would like to take this to a judge to file the civil action. At which time their attorney or a attorney that they, are able to hire would be the one who has to bring it. And that usually, typically is gonna be when all other methods have failed.
interesting, alright.
So
Just kinda
if
curious.
there's a violation, you would be, say someone comes to your office and says, hey, there's a violation or a property. As a board, we don't look at those case by case, you go to the prosecutor and say, hey, we have a violation, or you investigate it.
The prosecutors have always wanted the staff to investigate it, to
The
be
staff.
able to see whether there is a violation. Once we have enough evidence, we'll start that first letter.
Mhm.
So we have to work through our end of it before it can then go on to even the prosecutor. Unless, as we said earlier, unless there's some major
Okay.
threat.
Also, large portions of it are right out of state statute. We're not, coming up with, greater regulations and greater enforcement than that which is already consistent in state law. I think that there are a lot of avenues to be able to mitigate, violations and find solutions. And, as you guys, you've been on the board for a while now, you know that is always our goal, is to find solutions and to not, ruin people's lives, but to try to help them with the best of our ability within the parameters of the law. And I think that the way that this is written, right now, it's just an application that will be submitted to the county commissioners. So we put in the countless hours of work, and then it will be ultimately up to the county commissioners to determine whether or not they agree with it, or if they even wanna make any modifications to it. Even if we get through this stage, we have opportunity to speak with the commissioners and address, areas of concern at that, point as well. Same thing for the public. But I'm not saying that we can't make any changes at the moment either. If there's anything here that needs to be highlighted or tweaked, that's a substantive change. This is our opportunity before it does come before the commissioners.
Well, the clerical changes have been noted, right?
From today, yes.
But yes,
Yes, I accept that.
All right.
yeah, I don't have a lot to add. I think most of my questions got taken care of. I was a little uncertain because I was looking at Mr. Boland's letter. And I was like, okay, so the prosecutor action, but that's just for the prosecutor, and then there's a separate one up there for the county commissioners.
Correct.
So, once I realized that, I'm like, oh, okay. I guess I would put those together, but that's just, it doesn't matter. But yeah, I agree, and I think that we need to go ahead and do this or something very similar to it, because otherwise, we need to rip a whole bunch out of our ordinance. Or just dump the ordinance, because basically it's just a facade.
Suggestion.
It doesn't mean anything because we can't enforce it. And if the county as a whole wants to have an ordinance and enforce it, then we need to enforce it, otherwise we just need to get rid of the thing.
Well, we can't get rid of it, it's required by state law.
Actually, no. And also, I think the approach that we have is a finesse approach, it's not heavy-handed.
Yeah.
And that's important to me, not to have that heavy hand of government hovering over the people of Boundary County. But at the same time, protecting, people from, egregious violations of our ordinance. So we gotta provide that mechanism for our prosecuting attorney and commissioners and everybody to be able to go through the appropriate channels.
Gives us the ability to bring some, equality to those that would follow the rules and do things the right way versus the ones that just don't care, take their little fine. and
It's
just
the ones that don't care, the problem.
The bad actors are the ones that
Most
ruin it for
people-
everybody else, right,
This isn't gonna be an issue with.
right. So this gives us more meat to that side of things, but we still have all the discretion that we had before. We just now have more that we can do.
So, one little thing I wanted to make sure I understood properly, 4.6.7 notice the title, that's not, we're not writing in permission for the county to do a civil asset forfeiture type thing. We're just putting a notice on the title that there is an infraction.
Right.
It's not even a lien,
No,
No,
it's
no,
just a notice.
it's just.
just so prospective buyers would see it, or maybe a lender that's gonna loan on the property, they're gonna see that.
I think that's very important.
Right.
I understand buyer beware and all that, but you know, you can spend your entire life and then you go to buy a property and invest all of your life savings and you realize, what in the world, this is going on in my
Yeah.
property and now I inherited it.
And when you,
So-
any real estate transaction where you're gonna pull that title, they're gonna see that little asterisk and they go, what's that? Why is that on here?
It's just a cloud, it's
Yeah.
not,
Well, that's what
Not
I
a
thought,
lien.
if I really wanted to go ahead and
Important clarification, Wade. I-
triple check it, but I can read, I thought that's what it meant.
so what I'm thinking is, like you said, Gil, we've been through this time and time again, this is a distillation of everything we've talked about, all these points, you know, one by one. We go ahead and let's say we recommend that the commissioners approve this, they're gonna take a look at it again.
Yep.
If it gets approved, and we start using this code, if there are changes that need to be, if there's something that's not working out right, we can always come back at a later time and amend and then make revisions. So I think this is a really good, after all the, you know, the year that we put in on this, or maybe more than a year actually, I think this is a good place to start, implement it and see how it works.
Yeah, it's certainly an improvement.
It's a 1,000% improvement.
Yeah.
And you remember the old one, it said something like, you'd pay $100 and you'd pay another $100, and then 500, and that was it. And then, there's nothing else we could do. So we would address all those glitches and everything. I think this is a great place to at least start.
Am I hearing a
Let's
motion?
set it up and see
Is
if
that a
it
motion,
flies.
Rob?
Is that a motion there?
That's a motion. It's a roundabout kind of
You wanna
way.
read it? The official
I didn't
language?
see it.
It's
on the last page.
there's a staff report thingy, Rob,
Yeah.
a separate one,
Oh,
and it's
separate
on the
one.
back page of it. The thingy is a very
You know,
big.
would you mind doing it? Wait, I can't.
I'll do it, Wade, I'll do it. I move to recommend to the Board of County Commissioners approval of the request to repeal the current section 4 enforcement of the Boundary County zoning and subdivision ordinance and adopt a new section 4 enforcement as proposed in file number 23-0180, finding that the proposal is in accord with the comprehensive plan and the criteria of section 18 of the Boundary County land use ordinance based upon the findings and conclusions as written in the staff report.
Okay, that has been moved. Do I hear a second?
I'll second.
Rob seconds it. Any discussion on this?
I think we've done most of our stuff.
Yeah.
This is the last opportunity. All right. There being no further discussion, all those in favor signify by saying aye.
Aye.
I'm gonna abstain. Sorry,
You're gonna abstain or just be a no?
I guess, can I abstain? Is that legal?
I'll yes, it's legal.
I still don't like,
Here, hold on.
okay,
Any nays? Okay, no nays with one abstention.
Sorry.
That's Scott.
No, sorry,
that's Krabby Patty over here.
That's all right.
I don't like some of the wording and
Yeah,
I'm not a
mine's-
lawyer, so I can't vocalize it properly, so.
Okay,
I don't know if that'll make you able to vocalize it properly either.
thank you, everyone. That's the end of that section of our agenda. And, now on to new business.
Oh, it's not done.
No, we just got a couple,
Got a couple little agenda items, don't we?
Because I don't have a slide, I'm gonna skip over some information we prepared for you on our activity of 2023, so I'll just leave that for our next meeting. And then, so our last items are, We don't have a schedule yet for the, this particular code section to go on to the Board of Commissioners because we had to wait for your recommendation. So that'll be scheduled to the next available county commissioners meeting, allowing time for noticing to the newspaper. Sorry?
So it's like 5-6 weeks out.
It's always, you have to come at least a month ahead of time, so if we were here a month from today, we have to get it in the newspaper by next week. And then the next items that would be up for your consideration, we have no, files that are going to hearing next month. So that gives us an opportunity to talk about the subdivision code, land division code, as well as the expiration dates for placement permits. So we would intend to bring that back. At this time, one of our surveyors was here tonight, and I asked him if he might have time to come that night to talk about some of the specifics of the two codes we work with now, chapter 11 and chapter 20, and talk about some improvements. And you can recall, I think, that we talked about that pretty extensively in 23. It included some talk about road standards, but also about making the process a little bit easier. Not taking all those items like lot line adjustments to hearing, and looking at some design issues that might address some of our quilted designs that we've seen over time.
We had another, surveyor too, that,
Steve
Steve,
Moyer,
Moyer, yeah.
let's see if he can make it.
I would like him to do this because, he had a lot of comments in the past, I remember
Yes.
in meetings past, he had a lot of good
And
information.
he's been writing to me, I'll see if
Okay.
he's able.
So I had one more thing it's a question that I had as I was listening to our first item this evening, and that was, cause every time we do a zone change, we have to do a comp plan change. Is there a way to unsync those? How do we fix that? And if now is not the time to answer that, we can talk about that next time, but
Usually,
I'd be interested in fixing that so that we could
Streamline a little bit.
do something.
you try to avoid calling them the same thing, and you usually give your comp plan some broader, like, or a range of 2 to 5 acres, or uses are commercial light to industrial. So you're not so firm with it has to be this size and it has to be this use.
So our comp plan is just as specific as our ordinance, is
Yes,
the
it
problem?
is,
I
yeah.
see, okay. Alright. Well, that was an easy answer. It's not an easy solution, but it's an easy
No,
answer.
it's a can of worms you're not ready.
That's all I have.
That's all you had? All right, I'm gonna declare this meeting adjourned. Thank you, everyone.
I have 6:40.
1840.
All right.
Hey, thanks, Ron.